Say hello to the peeps, Preston. Say hello. Hi guys, welcome back to my channel. I hope everything is well. I hope you guys miss me. I miss you guys so much. Today we're doing a reaction video, something I've been wanting to do for a long time. Hopefully this is the start of that bag. Today we're reacting to day 2 of the assault case against Steffon Diggs. I hope you enjoy. Leave a comment, leave your opinion, and I hope you enjoy my legal take on things as a very experienced person, and a very experienced person with much more experience to come. And I love you guys so much. Thank you for always supporting me, and get ready to watch the video. Mwah. See you later.
Hello, subscribe, follow, Maria, Diouf, Maria, Diouf, Maria, Diouf.
Just reminder.
Morning. Just a reminder that you're still under oath.
Okay.
And Ms. Adams, again, as of the same as yesterday, if you could do your best to keep your voice up, that is appreciated.
Yes.
Thank you.
May I proceed, Your Honor?
Yes, thank you.
Thank you. Ms. Adams, on January 1st, 2026, you sent Steph's girlfriend a text message that later appeared on TMZ's website, correct?
Yes.
And in that text message, you told Steph's girlfriend that you were so sorry, but you couldn't talk to her, right?
Yes.
And you told Steph's girlfriend in that text message, I didn't say that, especially in the way it was written.
Yes.
Right? And you were talking about the statement that you made to the Dedham police, right?
It was a voicemail, and I didn't listen. I read it, the transcript, so I didn't know her voice.
When you told Steph's girlfriend on January 1st, 2020...
Why does she seem so like she's being sarcastic? Do you know what? Cross-examination is the most, I think, is so confrontational, because it's like, what, a minute and 30 in, and the attitude.
6.
I don't understand the question. I'm sorry. So
I
don't
haven't
wanna
finished my
answer it.
question. When you told Steph's girlfriend on January 1st, 2026, in a written text message, I didn't say that, you were referring to the statements that were reported in the press that you gave to the Dedham Police Department, correct?
I don't understand your question.
Did you or did you not write those words?
I don't understand your question. Without further explaining.
You can't testify under...
Listen, she definitely understood the question. This is a new one. Have I heard people say before, I don't understand the question? To be fair, what can you do if someone doesn't understand the question? But I feel like, at what point do we treat this as a hostile witness? Because this is a very simple question. But if someone says they don't understand the question, what can you actually do? Because you cannot force someone to understand something. Understanding anything is down to the person's intelligence, knowledge, etc. So understanding, so this is a tricky one, but she definitely understood the question. Come on.
Oath to this jury what you meant by the words you wrote to Steph's girlfriend on January 1st, 2026?
I'm sorry, I don't understand your question without further explaining.
You also asked Steph's girlfriend to, quote, Please call my mediator, and she will answer everything you need to know, but only in person and confidentially. Right?
Yes.
Your mediator's name is Lynette Marie, right?
Lynette Marie.
Thank you. She's also known as Lynette Marie Turner.
I don't know.
You don't know your mediator's last name?
I don't know her. She's married. I don't know her exact last name.
Your mediator works for a company called LMT Global, correct?
Yes, that's her company.
Your Honor, may I approach?
Yes.
Why? they're definitely gonna fight. Why do both of them have such an attitude? The day has only started. Why do both of them have so much? To be fair, I would be getting irritated as well if you're sitting there pretending you can't understand my questions. But this is crazy the way she flipped that. You know, it's a skill. It's Preston, what are you doing? What are you doing, Preston? It's definitely a skill to maintain professionalism, because we all have personalities, and listen, people will try your patience.
I'm showing you a corporate document from the state of Michigan.
Whoa.
It is an amended annual report filed by LMT Global Corporation. Can you please read the name of the president of that company?
Objection, Your Honor.
Sidebar.
Your mediator, Lynette Marie, issued a money demand to Steffon Diggs on December 29th, the day the criminal complaint in this case issued, right?
I'm not sure of the date.
Well, may I approach, Your Honor?
Yes.
If she recognizes it, yeah.
Do you recognize this email from L. Marie on December 29, 2025, to Steffon Diggs and a number of other people?
No, I don't recognize it.
You've never seen this money demand before?
I seen the money demand after I was... That's it. I don't recognize the email.
Testimony under oath is that your mediator made a money demand on December 29th for money for you from Mr. Diggs.
Money for past
the
wages.
The same day the criminal complaint in this case issued.
Listen, as someone giving evidence under oath, I know it's hard. I know it's like daunting. Do not interrupt the lawyer when they're cross-examining you. You just look nervous. People will start to doubt your credibility. She's clearly apprehensive. I think the best witnesses are the ones they answer in a calm manner. They speak respectfully. You're at the end of the day, you're in front of a jury, and unless you've got like a charming personality, the truth of the matter is, like, unless the jury is like buying your if you've got like an attitude, unless the jury likes it and it's like buy-in or understands why you're being so hostile, they'll definitely start looking at you sideways. So I look crazy, right? Definitely be respectful. Listen, the allegation.
And you didn't see it?
I can't answer that question.
I'm sorry?
I can't answer that question without explaining further.
Can't answer that question under oath.
Without explaining.
Your mediator demanded $19,000 on that date, didn't she?
For wages owed, yes.
Your Honor, I move to strike that.
Overruled. Answer stands.
Sorry?
Answer stands.
Thank you, Your Honor. You've made another money demand in this case, haven't you? Actually, before we get there,
I wish I went to law school in America and I practiced in America. I think for my theatrics and the type of personality I have, that's where I'd fit in. Because don't get me wrong, in the UK it's enjoyable. I love it, but you know, I just love they've just got like a lot of dramatics into them. Like over here, if we've got an objection, we just stand up or we intervene. Objection. Objection, Your Honor. Objection, Your Honor. I just love it. They're just like so. We've got that je ne sais quoi Americans. They're very dramatic. They're very extravagant. Over here, we're very formal, very. What's the word? Conservative, I think. I think we're very conservative. This is a crazy pause.
the
I didn't get a
19,000.
chance to answer the question.
Before we get there,
Are you withdrawing your
yes,
question,
the
counsel?
question is withdrawn. Thank you, Your Honor. After a money demand for $19,000 was provided to Steffon Diggs, on February 13th, you issued a public statement, didn't you?
Yes.
And in that public statement, you said, I have never sought money to settle this matter, right?
I haven't.
And by the middle of April, you had hired a lawyer to represent you, right?
For workers' comp.
That's a yes or no question, ma'am.
Yes, for workers' comp.
Your Honor, may the witness be instructed to please answer the questions posed.
Witness answered your question.
All right. And for workers' comp, the lawyer you hired, is she sitting in this room right now?
Yes.
And she helped you prepare for your testimony in this case, right?
She came to support me.
She came to the meeting with the Commonwealth's lawyer to help prepare you for your testimony in this case, correct?
I don't know how to answer that question.
You can't answer that question under oath, ma'am?
No,
You met with the prosecutor last Thursday, right? With your lawyer,
I
right?
was told to have a lawyer because you guys asked me to plead the fifth on some things. So I was instructed to have my lawyer come.
So your testimony under oath is that the Commonwealth's attorney instructed you to bring your private lawyer?
Or a lawyer, that you guys offered a lawyer, so I brought my private lawyer.
I'm sorry, when you say you guys, do you mean me, defense counsel for Mr. Diggs?
Yes.
Is your testimony under oath that I had some role in your preparation session with the district attorney's office to prepare you for your testimony in this case?
I was told that the defense said I needed to have a lawyer, or they were going to provide a lawyer, something in that context, about pleading the fifth, about messages. So
I think what happened, this is the thing, like, when people don't understand legal proceedings, it gets so complicated, and I think that's why everybody, that's one thing I stand by, everybody needs legal advice, everybody needs legal representation, because she completely misunderstood what happened. It's clear that obviously they needed her to plead the fifth, whatever situation. It must have been a preliminary matter or anything or something like that. And obviously she needs legal counsel, she needs advice. It's not simple of just, you know, the person turning up unless that's their decision. And they probably meant if you don't come with the provision, I think in American they just like, what is it? Over here we have legal aid. I don't know what they have in America, but public defendants, I think they have. That's what they call it. They just mean like if you don't come with anybody, then the court will provide you with a public defender, not someone from their side to then represent her, because that's obviously like plain conflict of interest and just like obviously wouldn't happen. But yeah, this is why I know it's daunting, especially if like she's a chef. She's obligated to know her rights, but she's not obligated to know how legal proceedings and everything goes on. But I just know from day in day out how hard it is for people that don't have the legal representation to understand legal proceedings and represent themselves and to even carry on. So bless her, she just misunderstood the whole thing.
I brought my lawyer, which was when I walked to the side of the judge yesterday.
Your personal lawyer is here today, correct?
On workers' comp.
She's with the law firm of Boston Law. That's a law firm here in Dorchester, Massachusetts.
Ma'am, I think that was I apologize, but you do need to keep your voice up. I don't know if you answered.
Okay.
Thank you.
Yes.
Thank you. Tell the jury how much I think you described her as a workers' comp lawyer.
I got her because I was injured on the job.
Guys, do you know, like, I noticed, like, the other day, I start cross-examining someone, and off the bat, animosity towards me just, you know, started as, like, to be honest, it started slowly until they were just, like, you know. My thing is, do you think, like, is it because the person is stressed, or do you think the person is thinking, like, for example, in this case where the accusations are horrible and you've got a defense lawyer who, for example, is a female, for a male who is alleged to have assaulted a woman. Do you think, like, the person is thinking, like, you're so horrible, how could you defend someone that's being accused of? Do you think that's what it is, or is the person just annoyed that they're there, they've got all these feelings, that's why they're so... Because I never understand animosity towards a defense lawyer, because they're there to do their job. It's not their fault. Like, there's nothing you can do. If this is the career you chose, this is what you do, you're there to be an officer of the court, to uphold the law and represent your client. I don't understand when people get rowdy, even with the judges, and judges can be quite harsh, because at the end of the day, it's a job. A person's there to do their job. They're not there. I often tell people, I'm not working against you, I'm just doing my job. Do you know what I mean? It's like, we need to respect each other. We need to be nice to lawyers.
And I needed to file a workers' comp case. Steffon Diggs did not have proper workers' and comp insurance.
The final portion of that answer will be stricken, and you will disregard it. Ms. Adams, if you could just listen to the question, answer the question, and if you need it rephrased, counsel will certainly rephrase it for you.
Okay.
Next question,
Thank you, Your Honor. 3 weeks ago, your lawyer demanded $5.5 million from Mr. Diggs, didn't he?
Mr. Diggs offered me $100,000 to recant my statement.
That is a yes.
That is the
Your Honor,
only...
Maybe be heard at sidebar, please.
I'm tired of this.
Objection, move this right. The last part of the witness's answer, the last part of the witness's response will be stricken as non-responsive. You will disregard it, and you will not consider it during your deliberations. tell them that as well. But courtrooms function in, and especially trials, unfold in a question and answer format. This is not an opportunity for you to interject your own narrative and evade responding to questions the court deems appropriate. And if you can...
Sorry to interrupt, Your Honor, but this is what I was telling you guys. Like, this is hostile. Like, at what point do we consider this a hostile witness? I get it. I can only imagine how hard. But that's not the way to give your evidence. And as the judge said, not an opportunity for you to start. I know this is like, and also it's obviously it's for the lawyer to control the answer, because you should never ask a question that you don't know the answer to. But, and, you know, it's your job to make sure the person's not rambling on and so on and so forth, same to the judge. But at what point, like, was this gonna start? Because she was clearly not answering the questions. Even I was getting, you know, riled up.
Continue to do so, your entire testimony may be stricken. Am I clear?
Yes.
The jurors.
All rise, jurors enter. May be seated.
Jurors, at this point, I just want to be clear on one point, all right? And it's the following. You may not consider anything you heard that was stricken from the record. When an answer is stricken from the record, it does not exist. And in determining what the facts are from this case.
Guys, do you know, like, one thing I always thought about jury, right? And judges' directions. My thing is, the judge will give you a direction. But a judge, obviously, yes, we're telling the jury, you cannot consider this. But can people unhear things? They can't unhear things. They can't unsee things. It's already in their mind. Like, what do you guys think about that? Because it goes back to in the UK and the use of jury. Because I just think that we're asking humans to disregard something they've just heard. And this is make your decision and disregard that. Okay, I have to make my decision, but I cannot take that into consideration. The person on paper will tell you they didn't, but in the back of their mind, they're already influenced.
You're sworn to determine those facts solely and exclusively from the evidence presented, and you may not consider any answer that I have stricken. All right? All right, thank you.
Proceed, Your Honor.
You may proceed. Thank you, counsel.
Ms. Adams, 3 weeks ago, your lawyer demanded $5.5 million from Steffon Diggs, correct?
That is client lawyer privilege. I cannot speak on that.
You believe that your lawyer's communications to Steffon Diggs are covered by your attorney-client privilege, ma'am?
I can't answer that question. I don't know the answer to that question.
You know that someone on your behalf has demanded $5.5 million from Steffon Diggs, don't you?
I have.
See, here, she would have been better off just saying, we don't want to continue with legal proceeding. This has been very stressful. I'd rather be compensated and move on with my life. Yes, members of the jury might think, well, this whole thing is for money. But yes, they can also think, fair enough, because at the end of the day, we're all humans. When you have legal proceedings, all you want to do is like get the best outcome, which is often to settle and just move on with your life. So I think, again, it's nerves, it's the whole situation. Sometimes you're just better off saying exactly what happened, because it's not client and lawyer privilege. There's no such thing when it comes to this, because these are instructions. They're not discussions. This is not legal advice. It's literally her lawyers acting on her behalf to get the settlement going. So there's no privilege there. And second, to be honest, why would they not just make this a without prejudice thing to stop his lawyers from mentioning it in this court? But anyway, it is what it is, isn't it?
I have a workers' comp claim, and
Your Honor?
I've explored all civil options.
Ma'am,
I don't understand.
are
the
you
question.
able to
Sorry.
answer
No.
that question?
No, I'm
Counsel,
not
restate
able
the
to.
question, please.
You know that someone on your behalf has demanded $5.5 million from Steffon Diggs.
Do you know that, Miss Adams?
No, I don't know. I'm sorry, I don't know how to answer the question. I don't understand.
I have no further questions, Your Honor.
Thank you.
May I read it?
Your Honor, before we direct, may we be heard at sidebar?
Of course.
Thank you.
Good morning.
Good morning.
Yesterday, defense counsel showed you a form about that you filled out to the police,
Yes.
and they made a point that you're the hand but not the forearm and elbow. May I approach? I'm putting a form in front of you. If you could just take a look at that and look up that, recognize it.
Yes.
And if I may direct the witness's attention. Could you read right here when it says the expected injury? Or
Objection, Your Honor.
Sustain.
is there anywhere on that form where you do note the forearm and forearm being used to choke you?
Objection. Your
Yes.
Sidebar.
The braids are clean. You know what? If you the braids.
On cross, I believe there's some questions about the text messages leading up to the assault.
Yes.
And, do you have still a binder in front of you?
Yes.
Do you mind opening to section 3 and to the pages ending in 114?
Okay.
Would you mind reading the text messages from page 114 to 117?
That is one thing, for some reason, I'm terrible at introducing evidence. For some reason, I don't know, I think it's the way my brain works. Like, I've got multiple tabs open. But for me to get a person and to remember the correct procedure to get the person to go to this page and introduce evidence and do this and do that, my mind is going 90. Especially if I know it's called. Sorry, so one trick I learned is to build up. So I say to myself, okay, I literally write on my notes, right, okay, this is where I want to go. So to get here, I'm going to ask this question and this question and this question, and I'm going to build it up. Okay, then I'm going to follow the formal procedure. So I literally go, build up, formal procedure, get to the page. And also, I think that's a good method because it's giving the judge a story. And then once we get to that story, here's the evidence for it. But unless I write it down and I tell my mind, I'm like 100 million notes all over the place and I lose structure. I find that, you guys already know from my YouTube videos, structure has been the key to my development. And only if I had structure during bar school, it wouldn't have been such a treacherous journey. But we made it. We made it.
The next text message doesn't say anything. I won't be paying you shit.
And do you mind just saying who's saying it?
Okay, I said the first. And ruining that bitch life is what I said. Mr. Diggs said, I won't be paying you shit. Fuck, I look like paying you and paying another chef. Is you high, bitch? Who the fuck give you money for your business? Who the fuck gotta give you money for your business? I don't gotta do a motherfucking thing. And you can get whoever you want. You got my address. Tell them to come take the money then. Fuck you talking about. I said bet. Pussy. I said pussy. Show me I'm pussy. Will do.
That's all.
That's it.
In your experience as a personal chef, is it common practice that when chefs get sent away, they get paid for the week that they get sent away?
Yes.
Objection.
Because that's the only job I have.
And I know on Cross it came out that you made a public statement where you said, I have never sought money to settle this case. When you said this case, was that referring to the criminal case? Or?
Yes.
Thank you. No further questions.
Very briefly. Go ahead.
That series of text messages that you just read, that was in response to you saying after you were fired by Mr. Diggs, you will be paying me out for the season and the money, I'm sorry, and this is on page 113 of Exhibit 3. You will be paying me out for the season.
See what she just did there? That's what I mean. I'm so like, if there's no structure, that'll be me like, just turn to this page, girl. Sorry, it's this page, girl.
And the money you said you would give me for my business. Wasted my fucking time being here because you got a fucking circus going on, right?
Yes.
So when he said he wouldn't be paying you, he was referring to your demand that after you leave your employment on December 2nd, he nonetheless continued to pay you $2,000 a week for the rest of the New England Patriots football season while you were not working for him, right?
That's not how it goes.
You will be paying me out for the season, right?
I was a contracted employee.
It's a yes or no question, ma'am.
I don't know how to answer that question. Sorry.
And before you said that, if you turn just one page back to page 112, what Mr. Diggs said to you that you were responding to was, "I'ma leave you be. Thank you for cooking for me for this season. I appreciate you. Hate it even got to this." That's what you were responding to when you told him he would be paying you out for the season, right?
No, it's a other full context of those messages.
Ma'am, was the message that came from Mr. Diggs that preceded your demand that you be paid out for the season, "Thank you for cooking for me this season. I appreciate you. I'ma leave you be."
Can you say that again?
You can look right down there on page 112. "I'ma leave you be."
What was your question?
I'm not finished. "Thank you for cooking for me for this season." You can read along and correct me if I get it wrong. "I appreciate you. Hate it even got like this." Right?
That's what it says, yes.
Okay. And you were really hoping that Mr. Diggs would give you some money so you could open your own restaurant, weren't you?
Objection.
That was our agreement.
That was what you wanted him to give you, right?
That was an agreement.
Ma'am, is this a contract suit?
Objection.
This is an assault.
That objection is sustained. The witness doesn't have to answer.
Withdrawn, Your Honor. Thank you.
There's no question in front of the witness.
You wanted him to pay you to open your own restaurant, right?
I want him to pay me past wages.
Okay. Just one moment, Your Honor, please. No further questions, Your Honor.
Thank you. Anything else?
No redirect, Your Honor.
All right. Thank you, ma'am. You may step down.
Commonwealth calls Kenneth Ellis of the Devon Police.
It's not easy, is it? It's not an easy situation to be in. Gosh, guys, well, what did you guys think of all of that? Listen, at the end of the day, it's a criminal trial. The evidence will show what the evidence will show. Sometimes people are wrongly convicted, sometimes they're correctly. To be honest, I need to deep in further to this case. But how did you feel about my reaction? Did you enjoy it? I hope you did. I hope you had a good time. Preston, say bye to everyone. He's a bit sick, the crazy guy. But hopefully I'll be able to make more reaction videos. I love watching them, so this is my new bag. And then I'll also have to finish Notes season 1. I need to record that last video. It's just, you guys will know, it's a lot's been going on. But anyway, make sure to like, subscribe, share it with a friend, and I'll see you in the next video. I love you so much. Bye bye.